Hello everyone and welcome back. In this video, I'm going to talk to you about the state's right, and I don't mean just Florida, but any state's right to detain somebody on a criminal case versus filing for a Marchman Act here in Florida. So here is the sort of scenario. I had a chat with a family. They have a loved one who has outstanding warrants in several other states. And that individual is now in Florida, has a long-standing substance use disorder. He would be a perfect fit for the Marchman Act, and the family wants to file. And I said, look, there's a couple of issues. First of all, the state's right. And when I say the states, I don't mean just Florida. I mean, these other jurisdictions have outstanding warrants for him. And their criminal warrants trump anything of a private civil nature here in Florida, because the Marchman Act is a private civil action, say, in this instance, between the parents and the child, the adult child. And I said, so you cannot use the Marchman Act to basically hide this individual and, avoid the outstanding warrants in these other states. Now, as a lawyer, I have ethical issues, right? I mean, I have to disclose this to the judge in Florida. By the way, judge, he meets Marchman Act criteria, but he has outstanding warrants in these other states. And I'm sure that if I was to put that in there, which I would do because I have an obligation to disclose it, and I don't hide stuff and play fast and loose with the judge, that court is going to say, hold on a second here. First of all, this is a private civil action, and these states have outstanding criminal warrants. You cannot use the Marchman Act to basically hide this person or overcome those criminal warrants. You need to go back to these courts in whatever states these are and address these warrants, whatever they happen to be for. And I also think that the judge here in Florida, if and when he or she would see in the petition that there are outstanding warrants in these other jurisdictions, in all likelihood, would actually notify the other jurisdictions. I think the judge would be obligated to do so because, like me, the judge is a licensed member of the Florida Bar, and we have certain ethical obligations, right? We don't hide people. We don't help somebody to avoid a court order in another jurisdiction, especially when it's a criminal case, because that means that the state of whoever is involved, and that state wants to detain this person and wants them back. And so, I mean, I've seen this happen here in Florida, where there's an outstanding criminal warrant in Florida, and the family comes to us and says, oh, can you Marchman Act this person? Well, yeah, I mean, it sounds like they meet criteria, but the state's right, any state, their right to detain your loved one is going to trump a private civil action under the Marchman Act. And not only that, and I'm going to speak for myself here, there is no way that I would frankly file that case for you because I have to disclose the warrants. I don't lie to the court. I won't let you lie to the court because those petitions that we file in Marchman Act cases are sworn under oath, subject to penalty of perjury. The way to do it, and the way I've done it in the past, I actually had a young man who came from a foreign state, another state. I had him under the Marchman Act for 2 years, and every 90 days we went back in and renewed it. How did I do that? We worked with a lawyer in this other state who went to the judge in the other state and said, hey, we would like to get him out of custody, out of jail, and we want to take him to Florida and put him into treatment. And they have this statute in Florida, which is unique to Florida, called the Marchman Act. And it would be a court order mandating him to stay in treatment. And we have a lawyer down there, Mr. Astor, who's willing to do it. And the judge said, fine, as long as he's under the Marchman Act. And so he came down here and I Marchman Acted him. And every 90 days for 2 years, I went back and I extended it and I extended it and I extended it. And we kept him down here and he stayed in treatment. And that's the way to handle it. But I put this out there because you have to understand the state's right. Remember, the state, when I say the state, it's not just criminal cases, it's the Baker Act. Remember how we've talked about in the past, how if somebody is in treatment, whether it's a Marchman Act or a guardianship or nothing, they're just there voluntarily. The state's right to detain you is absolute, and they can detain you through the criminal system, and they can detain you through the behavioral health system, the mental health system, the Baker Act. And every state has some version of the Baker Act, for the most part. Every state has a criminal justice system, for the most part. And so the state's right, any state's right, is going to trump your rights to initiate a private civil action under the Marchman Act to get your loved one into treatment. And so look, you just can't sweep this stuff under the rug. You got to deal with it. And it's a shame. I hope this gets resolved. I really would like to help this family, but things have to be done correctly. They have to be done in the right order. And while I was a prosecutor for many years, I did defense work for many years. If you need help with a criminal case, give us a call. I'd be happy to make a referral to somebody that I trust and respect who can handle criminal cases. So with that said, thank you for tuning in. I appreciate you. I would love a thumbs up and a subscription if you could to the channel, and I will see you in the next video. Bye-bye.